one thing that you mentioned about the executive order that I find problematic, not with your analysis, but with the order, is the notion that the reference to U.S. founding principles and the fact that that may be code for the notion that Sharia law is intrinsically compatible with the Constitution. Is there any way that over time for the courts to monitor whether in fact that is how it is misused, or is an attack on the order based on the fact that it could be so abused something that's a real-time thing that may be done in the courts? I don't know if I've articulated that.
Yeah, no, I hear your question. I'm not sure. I mean, I think at this point we're in we're in the preliminary injunction phase, right? That is, they're challenging the order on its face. Is the order itself advance a discriminatory purpose, and they can point to the sort of coded language that I mentioned, as well as all the extrinsic evidence about the campaign promises. And so, that's where we are now. If the order were to be upheld, or if they reissue the order and maintain this sort of loyalty to the Constitution as the sort of benchmark for deciding who's not dangerous, then there could well be as applied challenges by someone who said, I was excluded because I said I follow Islamic law, or I'm a believer, I'm a believer in this tenet that they think is un-American. Whether, how that sort of as applied challenge would go, I suspect is less likely to prevail than the facial challenge where we are now, for some of the reasons that Peter just mentioned in the difficulty of raising a specific challenge for why did they decide that I was dangerous. The court is likely to defer to the executive judgment about this particular person who's been dangerous in a way that I think that they won't in saying that the order is valid on its face for excluding 7 entire countries. You may know.
No, I think you're right about that.
All right, I don't think we've got that recorded. We're going to preserve that moment. Yes, sir.